Hello, everyone, and welcome to Uncivil Law. For today's case, we have litigation gone wrong. This is a case that went on for many years, and then on appeal, it turned out, oh, wait a second, the district court never had jurisdiction in the first place. So all that time, money, energy you spent over like the last decade is for naught. This is the decision of Linda Bull et al. Versus DePoy Orthopedics. In this case, we're going to learn how, checking out your jurisdictional statutes is probably something you should do some point in the case before you spend lots of money. So let's read this. The 12 cases consolidated in this appeal, so 12 lawsuits gone wrong, serve as yet another reminder that it behooves parties to be meticulous in jurisdiction. For some 200 years, it's been the rule that no matter the time and resources spent, an appellate court must wipe everything out if it occurred that the lower court had jurisdiction. Jurisdiction is kind of important. If a court doesn't have power to hear the case, then nothing really happened. Yeah. Here, though, even though 8 years have passed since the plaintiff was sued, everyone recognized the district court lacked diversity jurisdiction. We thus vacate the judgments. They never happened. The 8 years doesn't exist. Your 12 cases don't exist. That was a wonderful use of time. Good job by everybody. Since 2010, the District Court for the Northern District of Ohio has been home of this multi-district litigation involving this and medical device use in hip surgeries. So just a brief aside, when it says multi-district litigation, that is a legal term. If you ever wondered, and we have seen cases like this before, if you have multiple people suing on the same thing in lots of different places, which usually happens if there's a major incident and all the lawyers go sue the same person at the same time in all the cases in multiple places at once, right? So a thing happens. Someone takes notes of it. Lots of people take notes of it. And all the lawyers go run to their respective courthouses and file suit. So how do you deal with that in your federal system? Well, the federal system has an answer to that problem. Thank God. There's a multi-district panel that exists. So, once it's recognized that there's all these cases everywhere, there's a lot of issues in common. There's some small differences between the parties, but it's the same thing that happened. We can have one court resolve it all. So there's a multi-district panel that exists, and you go to the multi-district panel and you say, please consolidate all these cases in one place. So we only have to do this once. So that's what happened. So all these cases that were filed, God knows where, went to the multi-district panel and said, okay, they are now in the Northern District of Ohio. Why? Because we say they do. And that's going to be the court that's going to resolve all these issues in common so we don't have to decide this in 18 billion different places at once. So that's how we resolve that problem. Thank God for that. The plaintiffs in this complex litigation have generally asserted that the device was defective and plaintiffs give inadequate warning. At its peak, this litigation involved 8,500 cases with 12,000 plaintiffs. Lots of places. So yeah, we've narrowed it down because we've only got 12 cases now. It started out as 8,500 cases. So there's a lot of cases we had to consolidate. So this is 8,500 for the price of one, my friend. For you, my friend, special price. 8,500 for the price of one. Residents of the United States litigated most of these cases. In late 2013, the defense entered into a broad settlement with these group of plaintiffs. The district court has since implemented the agreement and appropriated an administrator to process these thousands of claims. So this is exactly what you'd expect from a class action, right? A thing happened. Lots of people took note. 8,500 people to take note, to be precise. So 8,500 people in 8,500 cases went and filed 8,500 lawsuits involving this thing that happened, involving this defective medical device. And the federal courts said, okay, we're just going to consolidate all this, thank God. So we only have to do this once. And they fought about it for a while. And as typical in a class action, they reached some kind of settlement. So they reached a settlement, they reached an agreement between the parties, and the district court said, thank God, we can dispose of this. It's over. But it's not over. It's not over. Because we have to go to appeal. Let's go to appeal. The foreign plaintiffs, by contrast, brought these 12 substance lawsuits. In 2012, they filed short-form complaints in the district court overseeing this multi-district litigation, an approach permitted by one of the court's orders. In the district court, the defendants never disputed diversity jurisdiction existed. Okay, so long story short, and we're going to get into the details, what is diversity jurisdiction? I'm so glad you asked. In federal court, there's two reasons you can be in federal court. One is that there's a federal cause of action, a federal lawsuit over some federal cause. That's reason one. Reason number two, you have a lawsuit between two parties of different states. So that's another reason that exceeds $75,000. It exceeds $75,000 in cost. So, if that's true, then you can also be in federal court. Okay, so that's diversity jurisdiction. We are in this case because we have people of different states and $75,000 of value or more. Well, more than $75,000 is the way the statute's written. So, yeah. Okay. Shortly after the suits were filed, they instead told plaintiffs they moved to dismiss the suits under the venue doctrine known as forum nonconveniens, a Latin phrase meaning inconvenient forum. The district court granted the motion. It issued 12 similar opinions dismissing these cases because Spain is a better forum. Okay, so there's issues of jurisdiction, issues of venue, and also an issue of a forum. There's what court should hear this case? And so let's pick something, right? And so they say, well, the Spanish courts are better. Now, without getting into the details, sure, why not? That makes sense. A lot of these things might be in Spain, the documents might be in Spain. Spanish courts are better equipped to handle this. Let them figure it out. It's a reasonable decision without going into the details of why, but sure. We could hear the case, but there's another forum that's more convenient. Let them hear the case. That's fine. This court reasoned the plaintiffs were residents of Spain. Their hip surgeries and follow-up care occurred there. The case-specific evidence was located there, and Spanish law likely applied. Makes sense. It also found the Spanish courts provide adequate forum for these people, and there wasn't an issue as to time. The court nevertheless conditioned its dismissal of these suits on defendants submitting jurisdiction of the Spanish court on their waiving any limitation defenses on satisfying final judgments, and the plaintiffs appealed. All right, so basically as to these 12 people, it said these people are Spanish, the documents are Spanish, the company is Spanish, the surgeries occurred in Spain. Seems like Spain occurred, all right? So we're going to say Spain is the issue, but we're going to say that you have to waive all the other defenses that would apply. Because there are other defenses that might apply as to this issue. So can you waive all those things so it can be Spain? And the plaintiff said, no, we're not going to waive all those things. We're going to appeal. We're going to make you do it. And this court said, yeah, okay, we'll make you. And said, but we have defenses, though. So let's find out about those defenses. Okay, let's press on. Before argument, we asked the parties whether the district court had diversity jurisdiction. The plaintiffs have since called this issue a technicality, which immediately lets you know you're in massive trouble. Because no, it's not a technicality. It's subject matter jurisdiction. It's essential. The federal courts are limited courts, like all courts for that matter, and they only have jurisdiction over the things they have jurisdiction over. And so, to the extent that diversity jurisdiction applies, it's not a technicality. The courts only have jurisdiction if the statute applies. Otherwise, they don't have jurisdiction. That's not a technicality. That doesn't have the court have power to act. So you're in trouble. Noting that this was the first time the issue of subject matter jurisdiction had been raised, which incidentally is one of the few issues that can be raised at any time, even if no one has ever brought it up ever before. Most things in law, you use it or you lose it. Subject matter jurisdiction isn't one of those things, though. Because the court never had power, it never existed. So I have actually seen it happen, and I can't name a case off the top of my head, but I've seen it happen where the Supreme Court themselves brings it up for the first time ever on their own initiative and then dismisses everything because of that issue. It can be brought up by anyone at any time. Doesn't matter if it's preserved or not. It's one of those few issues you don't have to preserve. Anyone can bring it up at any time, and if it's proven, you're done. So it was only brought up the first time now. Literally no one cares as far as the federal courts are concerned. Yeah, too bad. We think it's worthwhile to remind the litigants that a federal court entertaining a case that's not within its jurisdiction is no mere technical violation. It's not. They never had power in the first place. Ordinarily, it's the plaintiff's burden to determine that the court has jurisdiction. Hence, the first thing, not the last, would be to determine that the plaintiff should ask itself is whether the court would have jurisdiction. That's a good place to start, yes. This case proves why. After 8 years, the parties now concede the district court lacked the jurisdiction all along. Rightly so. 2 provisions in law give district court jurisdiction over civil actions that include foreign citizens and seek more than $75,000. So now we're going to get into the technicalities. What are the statutes that apply, and what does it say? Let's read it. Let's read it and realize what happened. The first statute grants jurisdiction over civil action between citizens of a state and citizens or subjects of a foreign state. So if Spanish citizens sued an Ohio citizen for more than $75,000, we'd have jurisdiction. Different people, different states. Great. The second grants jurisdiction over a civil action between citizens of different states, even where citizens are subjects of a foreign state are additional parties. So if an Ohio citizen sued a Michigan citizen and a Spanish citizen for more than $75,000, this jurisdiction would exist. Indeed, if citizens of different states are on both sides, most courts hold that statute permits it, even if foreign citizens are permitted to join on additional side. All right, so this is where things get into wonderfully, wonderfully technical issues, right? Wonderfully technical issues on which these things turn. Jurisdictions of different states, just jurisdictions of foreign states. So if there's a jurisdiction between two U.S. states, cool. If a foreign party is involved, cool. If it's a U.S. party versus a foreign party, cool. But that isn't exactly what happened here. Let's read on. What happens, though? What happens, though, if foreign citizens are on both sides of the dispute, but a state citizen is only on one side? Say a Spanish plaintiff sues defendants from both Ohio and the United Kingdom. This pattern does not fit the statute because citizens of different states do not fall on both sides. Yeah, you can't do that. There's only a citizen of one state, Ohio, in this fact pattern. There are not citizens of different states on both sides of the equation. So you don't have diversity because you don't have diversity of citizenship. You can't do that. And it doesn't fit A2 because we've read that provision to require complete diversity, meaning that only state citizens that are on one side of the dispute and only foreign citizens are on the other side of the other. Complete diversity. Yes. So when you have diversity of jurisdiction, you need complete diversity. This doesn't apply to class action sometimes, but it does here. So it's saying you need complete diversity and you didn't have it. You had foreign people on both sides of the equation. Spain was on both sides of the V mark. And that's not going to do it. So you don't have complete diversity. Oops. For what it's worth, other circuit courts that have addressed this have agreed with our reading. That rule dooms the diversity of jurisdiction in these cases. The complaints allege the plaintiffs who underwent hip surgeries are residents in Spain and citizens of either United Kingdom or Spain. Yet at least one defendant, Pry International, is incorporated in the United Kingdom and is its principal place of business there. On these facts, the plaintiffs cannot satisfy the statute. The section will not work because citizens of foreign states fall on both sides of the dispute, and so jurisdiction is lacking. And A3 will not work because citizens of different states don't fall on the different sides. While some defendants are citizens of a state, the plaintiffs identify no citizen plaintiffs. And that's where it killed you. The citizens of the different states are only on one side of the equation. That's what killed you. If you had citizens on different sides, on both sides of the V mark, you would have been fine, but you didn't. You didn't. You had a whole bunch of citizens of different states, but only on one side of the V. So you don't have diversity of citizenship because there's not diversity between the parties. So, oopses. Thus, the district court could not exercise diversity of jurisdiction. Yep, that's the way it reads. We therefore deny the plaintiff's motion to amend their complaints, vacate the district court's order conditionally dismissing it, and remand for proceedings consistent with this opinion. So that is the end of 8 years litigation in the case of Linda Bolt et al. Versus DeProy Orthopedics in various case numbers, as you can see on the right-hand side of the page. In this case, 12 different cases were brought. Unfortunately, no, not so much, because the federal law doesn't allow for it. Because there were definitely parties of foreign states on both sides of the equation, but unfortunately, citizens of different states only on one side. So there isn't diversity of citizenship. So, no, not so much. So the district court never had power over these cases. The district court doesn't have existence. So, I mean, for what it's worth, you may have a cause of action somewhere else, assuming that, you're not time barred. So, good luck with that if you're not time barred. But this case never happened. So go to Spain if you can, I guess, or go to the UK if you can, I guess. But you have no cause of action here. And so that's the end of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.